Hi, my name is Robert Shelley with Chelle Law, and my law firm assists professionals with employment contract issues. Today, I'm going to talk about, is an offer letter a contract? In short, most likely it is not. So, when a professional is entertaining a new position, many of the employers will offer an offer letter, also known as a letter of intent. And then in that letter, it will kind of break down the basics of the employment relationship. So it'll list compensation, potential bonus structure, probably the term of the agreement, how long it lasts, maybe a few of the benefits, if there are a non-compete, a non-solicit, if professional liability insurance is needed, maybe who pays for tail. So just kind of like basic bullet points of these are the things that are going to be incorporated into the employment contract. Now, it does make sense to negotiate the main terms of the agreement prior to signing an offer letter. It's kind of bad form to agree to a salary, get the offer letter, and then continue to negotiate after you've already negotiated. However, there are many times where you'll agree to an offer letter, and then the employer will follow up with an employment agreement. And then the terms of the employment agreement are maybe much different than you were expecting. Maybe the specific language of the non-compete was much more restrictive than you were anticipating. Or maybe if you're paid purely on collections, the collections ends as soon as the contract is terminated, and then you just missed out on 60 to 90 days of collections that you should get a percentage of. So once you sign the offer letter, the question is it a binding contract? And the short answer is no, it's not, unless there's specific language in the offer letter that states this is binding in some way, which would be extraordinarily rare. It's just not done. Maybe in like academia, when it's more of a kind of thorough offer letter, and that's all that they're providing, and then they're just referring out to a bunch of policies and procedures. But if it's just a normal professional environment, then no, the offer letter will generally just be a general, these are the terms that we've agreed upon. However, the professional can continue to negotiate even if they've signed an offer letter, and even in regards to the terms that they've already agreed to. The employer most likely will not be happy if you come back at them and ask them to renegotiate terms. But if you're going to do that, you need to explain why you're doing it. Meaning, yes, this salary at $250,000 annually made sense, but you're also giving me a 3-year non-compete that covers 5 counties, which is going to effectively make me move if I, once the agreement terminates. And taking that into account, $250 is not worth me taking this job. So giving the employer some kind of context as far as why you did agree to some kind of compensation at one point, but now at this point, it's no longer an amount that you're willing to work for, is important. And I think most smart employers will understand that nothing is final until you sign the actual employment agreement. So even though you've agreed to terms in the offer letter, it doesn't mean that you can't reopen those, but you got to keep in mind that it may tick off the employer in some way. Now, what about terms that aren't listed in the offer letter, but are listed in the employment agreement? Those are absolutely terms that you should try to negotiate. And when I say negotiate, what do? Well, if you have a signing bonus, ask for a little more. If you have a non-compete, try to reduce the amount of time of the non-compete, try to reduce the geographic restriction. If they're not going to pay for professional liability insurance or tail insurance after the contract ends, then try to work out some kind of agreement where they'll pay for all of it or maybe a portion of it. As I stated before, if there's some kind of bonuses involved, you want to make certain if you've earned those bonuses that you want to get them paid, even if you're not employed at the time that they're normally paid out, or maybe get them prorated. if there's some kind of forgiveness structure. So a lot of employees will get some kind of signing bonus. And then in the contract, it'll state if they leave before this period of time, they'll have to repay back a portion of it. If you have like annual forgiveness, then get that reduced to either quarterly or monthly forgiveness. So just to be specific, if you have a 2-year term on the agreement and you were given $20,000 signing bonus, it may state for each year you're here, it's forgiven 1/2. Well, it's better for the employee to get that reduced to a monthly, because if you leave in the middle of the year and it's yearly forgiveness, you missed out on 6 months of forgiveness. Whereas if it's monthly, you just have 6 of 12 months forgiven. So there's plenty that you can negotiate, even from when you've signed an offer letter to a contract. In general, it is not binding, and you can always renegotiate terms. Now, once you sign the employment agreement, then yes, those terms are final, and you'll have to stand by whatever you agreed to. But as far as the offer letter goes, it's still negotiable for the most part. If you have any questions, you can always call my law firm at the phone number listed below in the description, or you can reach us through our website, chellelaw.com. That's CHELLE law.com. And I appreciate your watch video. Thanks.